Okay, so picture this. A crime happens. Someone calls it in. But what actually happens next? Have you ever wondered how a criminal case really gets off the ground? I mean, how does it go from that first frantic phone call, navigate this massive labyrinth of the justice system, and eventually end up in a formal trial?
Well, welcome to this explainer. Today, we're going to decode the complete criminal investigation framework under the Code of Criminal Procedure, specifically sections 154 to 176. Now, whether you're a law student, a practicing attorney, a police officer, or just someone who's super fascinated by how the criminal justice system works, getting a grip on these rules is absolutely vital. Because look, this isn't just dusty textbook theory. This is the exact space where human liberty is either lost or preserved.
So, here's our game plan. We're going to trace the life of a case chronologically. We'll start with the FIR, look at the difference between cognizable and non-cognizable offenses, unpack police powers and their limits, dive into witness statements and confessions, check out the strict rules around arrest and remand, and finally, wrap things up with the final report, or the challan.
All right, let's jump right into part 1, the FIR, which is the absolute starting point of any investigation.
When it comes to Section 154, the law leaves literally no room for debate. The magic word here is shall. Registration is mandatory. If someone reports what's called a cognizable offense to a police station, the officer in charge doesn't get to say, well, let me think about it, or delay it to poke around first. No way. They have a strict statutory duty to write it down immediately.
And just to show you how seriously the courts take this, look at the Supreme Court's stance in Haji Muhammad Akram versus the state. They explicitly declare that the FIR is a vital document, not just some bureaucratic formality. It's literally the foundation of the prosecution's entire case. Why? Because it locks in the time, the place, and the initial story right off the bat, way before anyone has the time to consult a lawyer or fabricate details. It's the ultimate touchstone that all future evidence is going to be tested against.
Moving on to part 2, we need to talk about cognizable versus non-cognizable offenses.
You guys, this is arguably the most crucial distinction in all of criminal procedure. In a cognizable case, under Section 154, the police have sweeping powers. They must register the FIR, and they can hit the ground running, investigating, arresting, searching, all immediately. But then look at the flip side. In a non-cognizable case under Section 155, the police hit a massive judicial brick wall. They can't investigate, they can't arrest, and they certainly can't search without getting explicit permission from a magistrate first.
Okay, part 3, let's look at police powers and, just as importantly, their limitations. So normally, to search a premises, you'd need a warrant from a judge, right? But under Section 165, an officer can actually do a warrantless search, if and only if they follow some mandatory steps. First, they absolutely have to record the grounds for their belief in writing before they even start searching. Second, they have to call in 2 or more respectable locals to actually witness the search. And third, they have to hand over a signed list of anything and everything they end up seizing.
The absolutely crucial takeaway here? You can't just make up your reasons after the fact. In the Muhammad Ilyas case, the Lahore High Court ruled that writing down your reasons after conducting the search is completely illegal. This kind of post hoc rationalization makes the entire search invalid, meaning any evidence recovered can be successfully thrown out in court. These rules aren't just red tape. They exist for sure to prevent arbitrary invasions of our privacy.
All right, on to part 4, witness statements and confessions.
So during an investigation, the police are obviously going to talk to witnesses, and that happens under Section 161. But here is a massive, game-changing safeguard. A statement made to the police cannot be used as actual, substantive evidence of guilt during a trial. It can only be used later on to contradict or corroborate what a witness says in court. Now, contrast that with Section 164. A confession recorded by a magistrate under 164 can be used as hard evidence, but only if that magistrate goes to great lengths to ensure it was completely voluntary and free from any kind of coercion.
The Supreme Court really anchored this idea in the State versus Hazor Baksh. They ruled that the bar on using police statements as evidence against an accused person is absolute. And if you think about it, why is that? Well, because the police hold tremendous, intimidating power over people in their custody. The law simply assumes that a confession made to a cop might not be totally voluntary, so it just throws it out entirely. Period.
Let's shift gears to part 5, where the stakes get incredibly high: arrest and remand limits.
Article 10 of the Constitution and Section 61 of the CrPC lay down an unforgiving, very strict timeline. At hour 0,
The exact moment of arrest, the accused must immediately be told exactly why they're being arrested, and from that very second, the clock starts ticking. The police have a maximum of 24 hours to get that person in front of a magistrate. It's not a suggestion, it's a non-negotiable constitutional limit designed to stop secret or arbitrary detentions.
But what if the police need more time to investigate? Well, they have to ask the magistrate for what's called physical remand, but there is a hard, unbreakable ceiling here: 15. 15 days is the absolute maximum total time allowed for physical police custody under Section 167. A magistrate literally cannot grant a 16th day, no matter how complicated or high-profile the case might be.
And it's really important we understand the difference between the types of custody here. Physical remand means police custody. The accused is physically at the police station, highly vulnerable, and available for non-stop questioning and evidence recovery. Judicial remand, on the other hand, means the accused is transferred to a prison. They're now in court-controlled custody, totally away from the police. If the cops want to interrogate them now, they can't just walk into the cell. They need a judge's permission.
Now, a magistrate granting that physical remand, they are not just a rubber stamp for the police. As the Supreme Court highlighted in the Rana Maqbul Ahmad case, the magistrate is the primary judicial shield for the accused. They have to independently examine the police diaries. They have to assess if the accusation actually holds water. They must write down their reasons for granting remand. And, super critically, they must personally examine the accused to check for any signs of physical torture or abuse.
Which brings us to our final section, Part 6, the final report, also known as the Challen. This wrap-up phase is governed by Section 173. Basically, the investigating officer has to submit a final report to the magistrate. You can think of this document as the bridge between the police's on-the-ground investigation and the state's formal prosecution. It wraps up the whole shebang: the FIR, the witness statements, the forensics, the physical evidence, everything they've gathered. Now, there are really two main directions this report can go. If the police think they've got enough evidence, they submit a positive report, commonly called the Challan, which forwards the accused to face trial. But if they come up empty-handed or realize the whole case was basically fabricated, they submit what's called a B report or a cancellation report. This basically recommends to the court that the accused should be let go and the case dropped. But here's the catch. Even if the police want to drop the case, it doesn't just magically disappear. The Supreme Court made this super clear in Muhammad Yusuf versus the state. Accepting a B report is a judicial act, not just an administrative one. The magistrate has to independently evaluate all that evidence. They have to hear out the original person who complained. And get this, if the magistrate disagrees with the police's conclusion, they can flat out reject the B report and order the trial to begin anyway. Wild, right?
So when a court does accept the Challan and takes charge of the case, that's called taking cognizance, under Section 190. But keep in mind, taking cognizance is just a prima facie assessment. The judge is essentially just saying, yep, okay, there is enough material here to at least start a legal battle. It's absolutely not a declaration of guilt, and it is not the trial itself. The presumption of innocence, that remains entirely intact.
So we've walked through this whole fascinating framework together. The CrPC is clearly packed with these incredibly strict, mandatory safeguards: the non-negotiable 24-hour rule, the absolute ban on police confessions, the 15-day limit on physical remand. But here's the really critical question I want to leave you with today. With such robust protections existing on paper, where does the system break down in reality? And if you're studying or practicing this law, how are you going to use this framework to intervene and ensure that justice is actually served? Keep exploring, keep questioning, and thank you so much for joining me on this explainer.